Chair Novotny, would you like to move your bill before the committee with a recommendation that the House file is re-referred to the Committee on Judiciary, Finance, and Civil Law?
That is my motion.
Chair Novotny, please begin your testimony.
Bill 962 is in regards to what's commonly referred to as the Brady-Giglio bill. Brady-Giglio refers to a list of law enforcement officers that prosecutors keep who have allegations of untruthfulness or other incidents that call their credibility into question. There have been varying criteria prosecutors use to determine who gets put on a Brady-Giglio list. I authored House File 962 last year to put some standards, some uniformity and protections in place for this Brady-Giglio list. The bill includes the bill included a task force composed of stakeholders to come up with a uniform statewide standard for the Brady-Giglio list. We heard in February of last year, and although we did not pursue the statutory task force, I tasked the stakeholders with coming up with standards. The law enforcement associations and the county attorneys have been meeting over the last year, and they have come up with a framework for Brady-Giglio policies. Although I understand that there's additional work to be done on the data piece of this, and we hope to get that worked out before it goes to judiciary, the D3 amendment represents the work of the associations to date. So Vice Chair Woody, I would like to move to adopt DE3 amendment, and then I will have my testifiers come to speak.
Chair Novotny moves the adoption of the DE3 amendment. All in favor of adopting the DE3 amendment, say aye.
Aye.
All opposed, say nay. The motion prevails and the DE3 amendment is adopted. Please have your testifiers come forward, identify themselves for the record, and give the testimony. And first up is David Titus, Executive Director of Minnesota Police and Peace Officers Association. Next on deck is Mark Schneider, General Counsel, Law Enforcement Labor Services.
Good afternoon. I'm Dave Titus, Executive Director of the Minnesota Police and Peace Officers Association. Chair, committee, thank you for having me. We were summoned to give a progress report on this Brady bill, so I will not duplicate our previous extensive testimony on why there is a statutory need for fair, consistent, uniformed process of Brady application. County attorneys, chiefs, and sheriffs, the MPPA, our associations represent our respective professions, our respective members, and those members' priorities and interests. The MPPA represents rank and file cops. Those are our members, those are our priorities, their interests are our interests. Our position on this Brady bill has been consistent. We need a uniform Brady process. We need the ability to challenge a Brady designation. There should be no ability to discipline solely on the basis of a prosecutor's designation. The work done by the above associations has been positive. We appreciate the movement in regard to the ability to have Brady designation reconsidered and agreement that peace officer no-call lists cannot be utilized. That being said, as it relates to our original top 3 requirements, more work remains necessary for our full support in regard to the ability of a peace officer to request a third-party neutral review of a Brady designation, and a Brady designation alone cannot be the basis for discipline. With the goal of a fair process for Minnesota cops, we need 10 yards, and we've gained 4. At this point, in the interest of moving forward, keeping our advances and resolving differences, we support this amendment.
Thank you. Next up, Mark Schneider with General Counsel, Law Enforcement Labor Services. And on deck, Brian Wells, Cass County Sheriff. Go ahead if you want to identify yourself.
Yes, certainly. Thank you, members of the committee. My name is Mark Schneider. I am General Counsel of Law Enforcement Labor Services. LELS is a public safety union, the largest in the state of Minnesota with over 8,000 members. We represent public safety employees, including licensed peace officers, correctional officers, firefighters, and support staff in public safety agencies and offices. I've been working on the Brady bill for several years now. In fact, I testified before the committee last year, and I am happy to report and to say that there has been movement. But I would agree with Mr. Titus that while it's a 10-yard run to first down, maybe we are at 4 yards. And the reason I say that, and I think we are all in agreement and should be in agreement, that there needs to be consistency with a Brady-Giglio standard. And I think in my discussions with the county attorneys, I do not want to speak for them, the sheriffs and chiefs, there is consensus and understanding that that's important. I could be a Brady designated officer working in St. Louis County. If I relocate down to Mower County, I may not be Brady designated. There needs to be uniformity and consistency. We're getting there, but we're not there yet. The do not call list is a step in the right direction. There are also bargaining rights and grievance rights and rights under PELRA, the Public Employment Labor Relations Act, that relate to discipline within the agency. And the basis and the reason for the original iteration of 962 and the discipline prong of it was we are seeing, and I have personally experienced this as general counsel and counsel for other law enforcement officers, public safety employees, that a Brady designation, it's attempted to use that only for the basis of discipline without a deep dive into the facts supporting that Brady designation. And it's for these reasons that some sort of reconsideration review process is necessary. Again, the stakeholders have been talking about that and are moving in the right direction, but there is more work to be done. Thank you.
Thank you. Up next, Brian Welk. On deck, Jeff Potts.
Chair Novotny, Chair Moeller, and members of the committee, thank you and good afternoon. My name is Brian Welk, the Sheriff of Cass County. I'm here today on behalf of the Minnesota Sheriff's Association, representing Minnesota's 87 elected sheriffs, and we are in support of House File 962. From the beginning of this conversation around the Brady-Giglio policy and procedure, the Minnesota Sheriff's Association has had a seat at the table. We have participated in ongoing meetings with our law enforcement partners, prosecutors, labor representatives, and other stakeholders to help craft language that is thoughtful, balanced, and workable in real-world operations. This bill is the product of collaboration, not conflict. Sheriffs understand the importance of Brady-Giglio obligations. We know that credibility is fundamental to the justice system. When a deputy takes a stand, the integrity of that testimony matters to victims, to defendants, to prosecutors, and to the public. At the same time, we also understand the importance of fairness, clarity, and due process for the employees we supervise. House File 962 represents meaningful progress towards creating a consistent and transparent framework. It provides structure where ambiguity has existed. It promotes accountability while recognizing the operational realities faced by law enforcement agencies across Minnesota, from large metro offices to small rural counties. What is equally important is how this bill has been developed. The Minnesota Sheriff's Association values the perspectives of all the parties involved. We may not always agree on every detail, but we share a common goal, and that's maintaining the public trust while ensuring fairness in the system. We are confident that the continued work will result in a language that is acceptable to all stakeholders. The Sheriff's Association remains committed to staying at the table, working through the concerns, constructivity, and supporting a final product that strengthens both transparency and due process. Thank you, Mr. Chair and members. I'm happy to stand for any questions.
Thank you. Up next, Jeff Potts, on deck, Brad Johnson.
All right, thanks, Mr. Chair, members of the committee. Again, my name is Jeff Potts, Executive Director for the Minnesota Chiefs of Police Association, representing the more than 300 police chiefs across the state, as well as about 150 command staff members. First, I'd like to thank Chair Novotny for bringing this bill forward, as we feel there is a need for this type of legislation. I'm going to condense. The fine sheriff from Cass County covered a lot of what I was going to cover, so I'll mention just a couple more things here, but we just echo what you just heard from the sheriffs and as well as other testifiers. We do express strong support for a bill that will provide consistency and clarity on the issue of Brady-Giglio. After last session, and some of you were here and heard the bill, the debate that took place, the DE3 was developed in collaboration with stakeholders, led by the County Attorneys Association, but several law enforcement groups participated in those conversations. And in its current form, the bill does provide clarity on several really important definitions in Subdivision 1. Subdivision 2 provides consistency and clarity by requiring prosecuting authorities to implement a written policy to guide the process of determining how Brady-Giglio material will be handled. And Subdivisions 3 through 6 provide some additional clarity on how the data is to be used and secured. I will note that we are still working with the author and the stakeholder group on some provisions within the bill to ensure proper data retention of non-public data. We urge this committee to pass the bill here today so we can continue the work with the author and the stakeholders to address our concerns on data retention. I just want to say thank you for allowing us to be here today to testify in the bill. Thank you, Mr. Chair and members.
Thank you. Next up, Brad Johnson, and on deck, Jonathan Holitz.
Thank you, Chair and members. May it please the committee. My name is Brad Johnson. I'm the Anoka County Attorney, and I'm here today on behalf of the Minnesota County Attorneys Association. I've been leading the Minnesota County Attorneys Association Brady-Giglio Work Group, a group comprised of urban, rural, and suburban counties, for just about a year following the leadership of past Sherburne County Attorney Kathy Heaney, who is now retired. Our work group has spent the last year putting together and refining a separate toolkit that is available for use by all Minnesota County attorneys' offices in an effort to provide a consistent, predictable, simple, and secure framework to encourage law enforcement officers and public employee personnel data, to encourage the reliable management of that data in the context of Brady-Giglio related issues. We have also run point on working with our law enforcement partners to try to come to an agreed upon structure and statutory framework on Brady-Giglio material for you, the members of our legislature, to enact. That work has been very positive, as you've heard here today, and I'm grateful for the testimony of the other stakeholders who have reflected that as well. This effort's been a long time, or taken a long time, and candidly, we're not yet quite at the finish line. We're impressed with the speed that you all are moving with this season, and we think that that is good because it keeps things moving forward and it keeps us all incentivized to get to a good product for you. At the same time, we want broad consensus between the stakeholders responsible for carrying out this law. The language presented to you here today has yet to be blessed by our Minnesota County Attorneys Association Board of Directors, but it does reflect a reasonable framework, and it is a giant step forward by our work group that reflects those positive dialogues we've been having with our law enforcement partners. Indeed, we even met on it last week. You will hear today that there are some items that we still need to work out, primarily, and I really want to emphasize that this is a key one, the data sharing and security process. It is our hope that you will continue to give us the time necessary to work out and amend this legislation as it moves along to ensure that we can get it right and that all the important input is gathered and considered. We thank you for the time today and keeping this important issue before you, and I will now turn over to John Holitz, my colleague from the North Shore, who has been instrumental in this work group to explain amendments that we've made to the bill for you. And I'll be here if you have any questions during the bill's discussion. Thank you very much.
Thank you. Sir, you can state your name and begin your testimony.
Thank you. Thank you, the members of the committee. My name is John Holitz. I'm the Deputy St. Louis County Attorney at the tip of the North Shore. I'm going to repeat some of the things you've already heard. Consistency, predictability, security. Those are things that everybody wants on this, in this group. The fourth thing that we need is simplicity, and that's the simplicity of the data access and data retention, and that's what, as you've heard, what we're still working on. As written, I hope that you see that this shows prosecutors' commitments to working with law enforcement and other public employers to address the concerns that they've heard in previous testimony before this committee. Again, we've heard it in a couple of different sports analogies now. It doesn't contain the most, from prosecutors' perspective, the most critical, important piece, and that's that data access part that we're working hard to get to the conclusion on. But the rest is really, I'm hoping you see, is a good faith demonstration of our commitment, of prosecutors' commitment, MCAA's commitment to addressing that consistency, predictability, security, those three parts with the simple data access to come. My hope was to go through a couple of the specifics in here and show you how we have encapsulated some of those themes, our commitment to that consistency, predictability, and security. Subdivision 1 is, of course, definitional, and I'm going to skip over that because it's not as germane. But Subdivision 2, this is great examples of consistency, predictability, and security. This is requiring prosecutors to have a policy, implement a written policy to handle the processes of seeking, review, and reviewing personnel data and disclosing it when and if it's determined to be Brady-Giglio type material, disclosing it when it has to be done. It doesn't specify a particular policy, but it gives us some a really good floor to start from for some minimum policies. Of course, we've got 87 different counties, we've got an attorney general's office, and we've got a whole bunch of city prosecutors as well, and one size does not fit all. We recognize that, we know that, and so that's why we have some basic minimums, and as County Attorney Johnson alluded to, a toolkit to try to provide those tools to other members. Looking at Subdivision 3, this again is another example of that consistency and predictability. It talks about and requires prosecutors to make these determinations as they should under the law on disclosure on a case-by-case basis. It also talks about and prohibits prosecutors from having this do not call list. And I know the importance of that. I understand the importance of that. It makes sure that prosecutors don't overstep their Brady obligations and turn it into something it never was intended to be. That's an easy one for us to agree and include. The fourth subdivision, again, examples of that. Work group working towards consistency, predictability, and security. Some of the retaining the classification of data, retaining that data security, but yet allowing prosecutors to do their job when it comes to also providing it during administrative background checks and other areas to comply with our obligations. It also creates some additional authority for district courts to step in and safeguard that information for law enforcement. It also creates a criminal action consistent with the MGDPA Chapter 13 for abuse or misuse of this data, this private sensitive personnel data. Again, consistency, predictability, security. Subdivision 5 is our commitment to notice, providing notice of and asking the court to provide notice when the courts make decisions that might have impact like this. Court decisions can have bearing, can be Brady-Giglio, but this also causes, and hopefully causes the district court judge to make sure that they mean what they mean in their orders. If they mean it to have Brady-Giglio implications, this makes them mean it. Hopefully it causes them to pause, stop, think, and make a sound decision. I think to summarize, I think we've got a great framework for consistency, predictability, security, things that everybody has already testified to. Simple data access is the piece that we have to work on. It's not a simple answer, and that's why it's taking us a long time. Otherwise, on behalf of MCAA, we support this at this point.
Thank you. At this time, are there anyone else that wants to testify on this bill from the public? Not seeing any. Are there any questions for Chair Novotny or his testifiers regarding the bill? Representative Greenman.
Thank you, Mr. Chair. And just a question on the stakeholders that have been involved and consulted. I know that that was a big topic of conversation last year. As a former public defender, I've seen that we have testifying law enforcement and prosecutors. I'm wondering where, how the public defenders, public defense bar, and defendants' rights organizations, how they have been engaged in this bill, or if they have in this version.
So I can address that just very briefly. I know our association's been in conversation with the chief public defender on this, and I talked to him following last year's hearing and got a little bit of input and perspective from him on that. We've wanted to make sure there's been alignment mostly on the side of prosecutors and the law enforcement agencies first. There may be an appropriate time for further input from other interested groups down the road.
Go ahead, Representative.
Thank you, Mr. Chair. So what am I just correct in hearing that this language is alignment from prosecutors and law enforcement, but not the defense bar, defendants' rights, and public defenders? I know the defense bar is broader than public defenders.
Yeah, given that it's uniquely within the prosecution function and the executive branch function, we wanted to make sure there's alignment on that side before getting additional input. Thank you.
Anything else?
Yeah, just a quick comment, because I think the whole point of last session, we talked about a task force and just ensuring, I think we all share the goal of an agreement for a uniform standard. The hard part is what that standard is. And that is where I think it matters for the system to work, right? In an adversarial system, we need to ensure that the defense bar, that prosecutors, that law enforcement, and that folks representing the defendants, who ultimately, at the end of the day, it's their due process rights, are impacted. And so I know this is moving forward. I think it will be hard to support language coming onto the floor that doesn't include more than consultation, but some kind of agreement from all of those stakeholders. And I hope that that's the goal, because at the end of the day, doing justice and ensuring due process is what Brady-Giglio was about, and I hope that that's our goal too. Thank you.
Thank you. Chair Mueller.
Thank you, Mr. Chair, and thanks to Chair Novotny for your work on this. And I am prepared to support this today to keep it moving. And I definitely support the goals that have been stated. I do have another question about the stakeholders in addition to what Representative Greenman asked about. And I saw the letter in the packet from the League of Minnesota Cities and the Association of City Attorneys. And I called the league out yesterday because I didn't like their letter yesterday, but I did appreciate their letter today. And just want to make sure that they're also going to be included in the conversation. In addition to, when I read the language, and specifically at line 1.7 of the DE and 2.12, it talks about public employee and public employer, which is pretty broad. And so I think AFSCME and MAPE need to be part of that discussion. I'm thinking especially of folks that work in crime labs, and I can think even more broadly, first responders that are public employees. I mean, obviously Brady-Giglio applies to all of those witnesses, but that's a pretty broad term. And so I just want to make sure all of the right folks are at the table as this bill moves forward. Thank you.
Thank you. Representative Pinto.
Thank you, Mr. Chair. And sorry to follow our Chair Moeller. I did want to follow up on the exchange between Representative Greenman and the county attorney, just that what I was hearing saying, it makes sense to me that sort of there needs to be some the issues are so complicated in this. There's rights of law enforcement officers. There's certainly rights of defendants. I'd say there's ethical obligations of attorneys. And so I understood what you'd be saying is that there has to be a conversation among law enforcement prosecutors just to figure out like what even would those groups want to support. And I think we're hearing that that's still being figured out. I guess the piece that I want to make sure to follow up on though was your comment that sort of that has to be figured out. And then it would make sense that we're going to hear from folks who represent criminal defendants, making sure that those rights are protected. If that's coming up in the process, that makes a lot of sense to me. We're moving this on to another committee. I do want to make sure in the course of things, though, that those groups do have input. There are conversations for the many reasons that that's an important thing to do. So not getting in the way of this today, and it sounds like the conversations are continuing. And again, it makes sense to me if we're going to start with police and prosecutors and add others in, as long as that does in fact happen. So thank you, and thank you, Chair Novotny, for your work on this and to the testifiers. Thank you.
Thank you. Chair Novotny, closing comments.
Thank you, Chair Whitty. As I prepared this bill, I thought back in my career and thought about the times that a simple mistake or a misunderstanding could have resulted in me being placed on one of these lists. Think about the time that I took a report on a weekend of a fairly serious past action assault and sexual assault that had happened. And of course, I did all the reports and took a statement. And at that time, and I'm going to date myself here, we were using handheld dictaphones with tapes. And you would put the little tape in an envelope and you would drop them in the secretary's box and, you know, mark it priority, and they'd get done right away Monday morning. Well, I'm working nights and I get a call about 10 o'clock on a Monday morning because the head of investigations had gone through the ICRs and saw that I took this report on the ICR, but they went looking for the tape and they couldn't find a tape. And on about 3 hours of sleep, I got a very angry phone call on why wasn't a report done. And, you know, in my sleep-aroused stupor, you know, I did do the report and I did throw it in Donna's box, and immediately got up and was going to go into work to figure this out and do another report. And, you know, from the tone and tenor of the chief investigator, I was in big trouble. And before I could get to the office, the secretary had looked underneath her typewriter. That's how old it was. They were using an actual typewriter, and that tape was underneath the typewriter. Had that not been found, that could have, you know, how would that affected me? Would that be a very serious case? Would that have questioned my reliability in going forward? And I also would like to point out that I didn't always have this easygoing, laissez-faire attitude that I have now. That there was a time when I was younger and I used to have run-ins with county attorneys and judges on cases, and how without a standard, getting on one county attorney or one judge's bad side, and I have done that both, just from my attitude that would result in me putting on this list and be a cloud over my career for the rest of my time. In all actuality, doing disciplines and doing terminations of employment as a supervisor, so many of these things that we look at based on truthfulness or, you know, falsifying testimony, I believe most departments are like me now. If there's something that's really going to impair their ability to testify, they're going to be terminated before that. We want a uniform standard. It's been, you know, the notes that I came up with before they even heard everybody talk. We want consistency, we want fairness, and we want it to be appealable, so that, you know, one disagreement with one person won't result in a career being destroyed. So that's why it's important. This is mostly, you know, and it really affects the state employees, the troopers, the game wardens, someone that's moving throughout the state. You know, and we've seen past cases where you have a county attorney in one, or a judge in one county that has their view of how things were supposed to be handled, and you go to a different county attorney and they're not happy with how that past incident was happened, and all of a sudden you're on a list. We do have the commitment from all the stakeholders that were involved in this that we're going to keep working on it. And I hope we can get to the point where we do have a statewide consistent standard. With that, I would appreciate your vote.
Thank you, Chair Novotny. Chair Novotny renews his motion that House File 962, as amended, is re-referred to the Judiciary Committee. All in favor, say aye. Aye. All opposed, say nay. Nay. Motion carries, and House File 962, as amended, is re-referred to Judiciary. Thank you, Chair Novotny, and to your testifiers.